Hello and welcome to the fifth episode of Temple Podcast. Today, Temple Group will be commenting on some of the amendments brought to the law governing employment this year. It is commonly known that employment law governs relationships on a daily basis, and at times it is difficult when the question of interpreting a provision of the law arises. It becomes even more challenging when we talk about amendment to the existing law. If we take work from home as an example, this practice would have been an alien in 2020. But when we talk about someone working from home presently, no one would be surprised. In fact, the national lockdown further to the COVID-19 pandemic rendered numerous organizations to question their survival, but the work from home concept arose as a game changer. It would be nothing less but an agreed fact that employers and workers adapted to the practice pretty soon and very well. Since it was a novel practice concerning the labour force, the government had to intervene and proceeded by making the Workers' Rights Act Working from Home Regulations 2020. As it is common knowledge, it is with time and practice that loopholes are identified, and the Working from Home Regulation is no exception. One of the uncertainties was identified when the country was struck by Cyclone Batsirai, and the meteorological station issued a Cyclone Warning Class 3, which was followed by a Warning Class 4. Prior to the pandemic and the practice of working from home, except for some employees who are mandatorily required to be at their place of work, the general rule was when the country is under Cyclone Warning Class 3 or 4, the worker may absent from work and shall be paid his remuneration until there is no cyclone warning in force. Workers are entitled to this privilege to mainly take precautionary measures in securing their houses, for example, during the passage of a cyclone. Now, with the work from home concept readily available in February 2022, some employers required workers to work from home whilst the country was under warning cyclone class 3 and 4. In the absence of any law governing this specific matter, workers had to follow the instruction of their employers. To remedy this uncertainty, the law was amended, providing that in the event a worker is required by his or her employer to work even from home whilst the country is under Cyclone Warning Class 3 or 4, the worker shall be paid in addition to the remuneration due to him 3 times the basic rate per hour in respect of every hour of work performed. Now, another interesting amendment which requires a detailed study is the new provision of reinstatement in the Workers' Rights Act. Reinstatement of workers to their posts following termination of employment is not new. Previously, the question of reinstatement of unionized workers on specific circumstances were already being dealt with by the Employment Relations Tribunal. The tribunal powers have been enlarged to deal with more instances and decide as to whether to reinstate a worker, whether part of a union or not. Previously, when a worker was terminated from employment and claimed that his or her termination was unjustified, the remedy available was to claim for severance allowance before the industrial court or damages before the relevant court. Now it appears that there are 2 remedies available to a worker who has been unfairly dismissed. In fact, instead of the court avenue, the worker may register a complaint for reinstatement to the Department of Labour and Industrial Relations of the Ministry of Labour, Human Resource Development and Training, more commonly known as the Labour Office. The matter would then be referred to the Employment Relations Tribunal after having assessed by the supervising officer of the ministry. The tribunal will accordingly consider whether the claim for reinstatement of a worker is justified and, subject to the consent of the worker, order that the worker be reinstated and be paid his remuneration, or the tribunal may equally order for the payment of severance allowance in the same manner that the industrial court would have. An important aspect of this amendment is that the order of the tribunal will have the same force as an order of the industrial court. What remain unclear are the rules and procedures governing the new remedy under the law. The question to be considered is how will the said worker who may have been terminated further to a disciplinary committee for, let us say, misconduct or poor performance be welcomed back. We may expect some new rules and regulations to be made to shed light as to how will the matter be dealt with. The other noteworthy amendment brought by this year's Finance Act is the additional category of leave with pay, that is leave to care for sick child under the age of 18. In fact, now a worker shall be granted up to 10 days leave with pay for every period of 12 consecutive months at his option against any of his paid leave entitlement be it annual leave, sick leave, or vacation leave, to take care of his sick child subject to some conditions. Every amendment will bring more debates and different school of thoughts as to its interpretation, and in the event that it is unclear until a court of law pronounces itself. Employment law has been subject to numerous amendments this year, and more rules and amendments are expected. Thank you.